We're live.
All right, good afternoon, everyone. Sorry about the delay. Today is March 16, 2021. We have one bill on the docket today with Senator Carter with Senate Bill 395. So Senator Carter, my apologies for the delay. The floor is yours.
Thank you, Mr. Chair, and thank you, members of the committee. I want to give you a special thanks because I know that my bill stands between us and one of our very rigorous voting sessions. I also realize that some of us have developed a bit of fatigue because we've had such heavy issues already this session. But I want to stress to you that this is an important bill and probably should have been heard earlier with some of our other justice bills, but it was a drafting error that caused us to delay the hearing of it. So I'd really appreciate you being somewhat forgiving from the fact that it is late and separated from some of the other bills. Committee, I realize that both the word felony and the word murder each are unsympathetic words, and strung together, they are doubly repellent. But the words themselves can't compare to the actual situation in Maryland, where we are still having the practice of charging juveniles with felony murder. So Senate Bill 395 would end that practice. Under current law, a juvenile can be convicted of first-degree murder even though they haven't actually killed the victim or intended to commit a murder due to the felony murder doctrine. Unlike premeditated first-degree murder, the state is not required in these cases to prove intent to commit murder or in order to obtain a conviction for felony murder. Instead, the state need only prove that the juvenile was participating in a felony when a loss of life occurred. The mandatory sentence for first-degree murder is a life sentence. Sorry, I'm having all kinds of distractions today. Apologize for that. The intention of this bill is to prevent the state from being able to seek a felony murder conviction against a juvenile and to end the practice of sentencing juveniles to life in prison for murders they have not actually committed. I remember last year when I presented this bill, I talked about a schoolmate that I'd gone to school with who, within a week of graduation, wound up getting charged, prosecuted, and sentenced for felony murder because he was sitting in a car where another person in the car jumped out of the car and wound up committing a robbery. The victim wound up having a gun, and that other person was shot. It was really a horrible situation, but it really highlights how horrible felony murder can be, where someone can simply be present, maybe not even intentionally be participating in a felony, and even if they've never put their hands on a weapon, never had an intention to commit that crime, they can wind up being prosecuted for felony murder and convicted of felony murder. In that case, my schoolmate was a child. He was 17 years old, about to turn 18, and that was his situation. Since that time, the Supreme Court has recognized that children should be treated differently than adults in our criminal justice system for the purpose of sentencing in a series of recent decisions. In Roper v. Simmons, the Supreme Court abolished the death penalty for juveniles based on the 8th and 14th Amendments. The court banned mandatory life without the possibility of parole sentences for juveniles convicted of non-homicide crimes in Graham v. Florida. And in Miller v. Alabama, the court extended its holding in Graham and held that mandatory life without the possibility of parole sentences in homicide cases against juveniles are cruel and unusual under the 8th Amendment. In all of these three cases, the court based its decisions on cognitive science research from physicians and neuroscientists that conclusively demonstrates that the brain continues to develop well into a person's mid-20s, and the frontal cortex, which controls for risk and impulse control, is among the last parts to develop. This makes juveniles more likely to succumb to peer pressure and take uncalculated risks. Because the brain is still developing for these juvenile offenders, the court recognized that juveniles have a decreased culpability for such offenses because they are not able to completely grasp the severity of such crimes. So charging juveniles with felony murder is inconsistent with the Supreme Court's finding on juvenile sentences. Sentencing. Proponents of felony murder doctrine argue that it is an important deterrent. They claim that if individuals know that participating in an inherently dangerous felony could lead to culpability for a murder, even one that he or she does not commit, they are less likely to commit the underlying felony. Assuming the doctrine really does hold some deterrent value, because juveniles are less able to anticipate risk and weigh their consequences, whatever deterrent effect the felony murder doctrine may have is lost on juveniles. Experts on brain development note that juveniles are still developing their brains and that persons under the age of 18 have not fully developed appreciation for consequences, long-term planning, or cost-benefit analyses. These are all pivotal aspects of the brain and cognitive function that would impact an individual's thought process in planning considerations and potentially acting on a felony. For these reasons, juveniles cannot fully appreciate the potential long-term consequences of engaging in a felony, especially in predicting a loss of life that they are not anticipating as a result of that felony. Additionally, felony murder rules are largely obscure, unknown to many people, especially juveniles with little knowledge of more obscure criminal laws and the legal system. Between the still developing brain and the lack of knowledge of felony murder laws, there is little deterrent benefit that the felony murder doctrine rule has or can ever have for juveniles who are convicted of felonies. Because felony murder is charged under the first-degree murder statute, it is unclear how many juveniles are serving a life sentence for felony murder conviction. There are over 300 juveniles serving life sentences in Maryland now. It is likely that a sizable portion of those juvenile individuals are serving sentences for felony murder. Abolishing the felony murder doctrine for juveniles outright is an important step towards addressing the state's system of mass incarceration. That said, we cannot ignore the racial disparities that also exist. For this reason, Senate Bill 395 also provides retroactive relief for those already serving the sentences for felony murder conviction when they were juveniles. Defendants who can demonstrate that they are serving a life sentence for a felony murder conviction from an offense when they were still juveniles can petition the court for a resentencing that is not to exceed the penalty in place for a second-degree murder at the time of the offense, either 30 or 40 years. I repeat, 30 or 40 years. This approach will allow the state to maintain its conviction, avoiding costly and difficult litigation while providing those sentenced to life as juveniles for felony murder the hope and real possibility of one day rejoining their communities. This bill is about accountability and proportionality. Juveniles will still be held accountable for the crimes they commit. They can still be charged as adults, and in appropriate cases where there is evidence the juvenile played a direct role in a murder of another person, they can be charged with first-degree premeditated murder, second-degree murder, or conspiracy. In all other cases, juveniles will still be liable for the underlying felonies that they have committed. This bill is about holding juveniles accountable for what they have actually done and will end the practice of sentencing them to life in prison for what they have not actually done. I urge you to support this important step towards a more just system for the children of Maryland. Thank you.
So thank you, Senator Carter, and thank you for bringing this before us. And again, sorry for the scheduling delay, but I'm glad we got it all fixed up. And you have the second best ringtone on the committee. So here we go. All right, we're going to move on to your primary witness, which is Ms. Meadows. Ms. Meadows is the primary. You'll have 5 minutes. The floor is yours.
Good afternoon, and thank you to the committee for allowing us to be heard on this bill. My name is Lila Meadows, and I'm a faculty member at the University of Maryland School of Law. Senate Bill 395 seeks to end the practice of charging children with felony murder and provides a mechanism to resentence individuals who were convicted and sentenced for a first-degree felony murder that occurred when they were a juvenile. Senator Carter's testimony, I think, hit on most of the points that I wanted to cover. And so I'm going to go a little bit off script here. And there are just a couple of things that I want to highlight for the committee. The first is just what a rare exception in our criminal law statutes felony murder is. As Senator Carter noted, we allow the state to skip proving intent. which means that they don't have to show intent, they don't have to show premeditation for a first-degree murder conviction that carries a life sentence. That's truly exceptional in our criminal law. There aren't very many criminal law statutes where we allow the state to impose what essentially amounts as a strict liability measure, and certainly none that I can think of that carry a life sentence. And we've tolerated this in the law in the United States, in the states that haven't yet abolished it, because of this idea of foreseeability, that you should be able to foresee if you're going to participate in a dangerous felony, you sort of should be able to foresee that a murder might occur. But as Senator Carter noted, what we know about juvenile brain science and development really negates that. It just doesn't hold. And so I'm not going to belabor the point because I think that Senator Carter made it. And I know that this committee has heard a lot of testimony about that this session for other bills. And so again, I kind of want to pivot my testimony and say that this is an issue that I'm familiar with both as an academic, as an attorney who practices criminal law, but also as someone who has a family member that was a victim of a felony murder. My grandfather was shot and killed by 3 juveniles just blocks from where I live now in Baltimore City, who attended Dunbar High School at the time, where I went on to volunteer for 8 years working with at-risk youth. And what I can tell you about that is that the felony murder doctrine wasn't necessary for accountability in that case, and it didn't bring a greater measure of justice to my family to know that there were 2 children who did not pull the trigger that day that went to prison for the rest of their lives for that murder. It certainly didn't make the loss any easier for my family, for my mother, who was plunged into homelessness after that murder. And I don't think that it brought a greater understanding as to how 3 children walked out of high school and committed a robbery murder, which probably would have brought the greatest healing of all to my family. And so incarceration and a life sentence wasn't the solution that the victim of that crime needed. I can tell you that. And I don't think that it was necessary for justice either. I want to echo what Senator Carter said, that this bill is about proportionality and accountability, and a life sentence for children is really not appropriate in these cases. Finally, I know that this committee has taken up several other bills that deal with reforms impacting juveniles and other long sentence servers. It's been a privilege to work with several of you on those efforts. They're all essential to chipping away at the mass incarceration crisis Maryland finds itself in. And while those bills also provide some retroactive relief, I urge you to consider this bill and to take action to reform Maryland's use of the felony murder doctrine. Charging children with felony murder is fundamentally inconsistent with what we know about juvenile brain development and emerging trends in juvenile sentencing set by the Supreme Court. And so I urge you to consider this issue seriously and to issue a favorable report. Thank you.
Excellent. Thank you, Ms. Meadows. And next we'll have Ms. Sutter. Erica, you're up.
Thank you. Thank you very much. Thank you for allowing us to be heard today. My name's Erica Suter. I'm a post-conviction and appellate criminal defense attorney, and I'm vice president of the Maryland Criminal Defense Attorneys Association. I'm here in that capacity, testifying in support of Senate Bill 395. I wanted to take a moment to just talk about sort of the logistics of how this process would work as laid out in the bill. Going forward, children could no longer be charged with felony murder. They could still be charged with first-degree premeditated murder, conspiracy to commit first-degree premeditated murder. They could also be charged under a theory of accomplice liability. Second-degree murder remains on the table, and of course, they could be held responsible for the underlying felony. In short, prosecutors would retain the ability to charge and punish defendants for the crimes that they actually commit. Now, retroactively, and I'm aware the judiciary did issue a brief statement, I believe, in opposition to this bill, but I believe that opposition was based on the unamended bill. And the amendments should, I think, take care of that concern. Retroactively, a person who was convicted of felony murder, who was a child at the time of the crime, would be eligible for resentencing, the maximum sentence being the penalty for second-degree murder at the time of the crime, either 30 or 40 years. Now, because the Department of Corrections doesn't track whether somebody is serving a sentence for premeditated first-degree murder versus felony murder, there's a little bit of a process to sort of uncover who is eligible for relief. And so a defendant would have to petition the court, identifying them as being members of that category, being a juvenile at the time of the crime and being convicted of felony murder. The court would then hold a hearing to determine, again, simply whether or not the defendant falls into that category, that they're eligible for relief. If the court found that they were eligible for relief, they fall into that category, then they would be resentenced, the maximum sentence being the penalty for second-degree murder. I would urge you to have a favorable report on this bill. Thank you.
Excellent. Thank you, Ms. Suter. And next we will go on to Ms. Kemmons. Rachel, there you are.
Here I am. Thank you. Good afternoon, and thank you again for accepting our testimony. My name is Rachel Kemmons, and I'm here on behalf of the Public Defender's Office to ask the committee for a favorable report on this bill. The premise of the felony murder doctrine is that a killing that occurs during the commission of a felony is foreseeable to all those participating in the felony. But as applied to children, this law violates the Eighth Amendment's prescription against excessive and disproportionate sentences. A mandatory life sentence for a child who participates in a felony, but neither committed murder nor could have foreseen that murder might occur, is excessive and disproportionate. Sending a child to prison for life is excessive and disproportionate because children have lower moral culpability, less amenability to deterrence, and a greater capacity for reform than their adult counterparts. Let me tell you about Warren Hinson, who was a homeless 17-year-old boy when he and a friend broke into a house they mistakenly believed was empty. The homeowner was armed and shot Warren, and Warren's friend shot and killed the homeowner. Warren was convicted of felony murder and sentenced to life in prison. 16-year-old Sean Blout's crime was standing behind his adult co-defendant who announced a holdup of a gas station and wound up shooting the attendant. The state conceded that Sean had no idea that anyone would be shot. Sean was offered a plea deal of 10 years for robbery, but unable to comprehend that he could be held accountable for the death of the attendant, he went to trial, was convicted of felony murder, and sentenced to life plus 20 years consecutive. This panel no doubt remembers Curtis Brooks, who joined Senator Benson's effort last year, a 15-year-old boy, also homeless, who joined a group of boys in attempting to steal a car. Curtis was handed a gun and told to fire a distraction shot into the air, which he did. But without warning, one of the other boys shot the driver in the head, and Curtis was convicted of felony murder and sentenced to life without parole. These few examples demonstrate that Maryland's felony law, as applied to children, exacts a grave injustice that demands reform. Thank you very much.
Thank you. Thank you very much. And with that, that'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel. And first up is Mr. Schellenberger.
Mr. Chair, thank you very much, members of the committee. Scott Schellenberger, State's Attorney for Baltimore County, in opposition to the bill. So felony murder existed at common law. It's been around, and Maryland adopted decades ago to make felony murder first-degree murder. And there's a very good reason for that. And please take a look at my written testimony that has a classic example in it of robbers working in concert. And that's the one thing that I need to make sure we point out is that we do have to point out that there is a causation connection between the murder and the felony. Take the case of Amy Caprio, the officer run over by Dante Harris in Perry Hall. The three co-defendants were in burglarizing multiple houses. You don't need a getaway driver if you're not breaking into houses. So by breaking into houses, an enumerated felony, and then your co-defendant who's going to drive you away, running over and killing someone, that is classic felony murder, as is the robbery case that I point out. The other thing that's very damaging about this bill is the second part, where now all these juveniles who've been convicted of felony murder are going to get a look back. Mr. Chair, I know I sent to you the rule committee from last Friday. They outdid you. They're giving everybody a look back, and not only one look back, but one look back every 6 years. So yours only gives one look back. But what that does is it says if I can't prove the new law that wasn't in effect when I convicted the person. Now they're guilty of second-degree murder. First, that means the Caprio family has to come to court 4 more times, in addition to the 20 times when the rule goes through. And that's not just for the Caprios, that's every felony murder. The other thing that's difficult for me to understand, and I'd be love to hear from my constitutional law professors, how can you be found guilty of a crime that was never called to trial? You're called to trial for either a trial on first-degree murder or a guilty plea on first-degree murder, felony murder, and now suddenly the judge has to strike that and enter second degree? How is that allowed or even constitutional? So the other place that I heard a disagreement is that they said nowhere else in the law is there any kind of strict liability. Not true. Take a look at the first-degree rape statute. If 2 or more individuals participate in the sexual assault and rape of an individual, then all of them can be convicted of first-degree rape. And that includes the person who's, thank you, that includes the person who is the accomplice by watching the door, or the accomplice who's outside in the car to drive them away. I believe that this goes too far. We need to keep it. And I urge an unfavorable report and look forward to questions.
Excellent. Thank you very much. And I know we had a conversation on Friday after the Rules Committee met. It was referenced on the floor today, and I'll be in touch with both you and Ms. Meadows so that we can provide some greater clarity and background for the committee. But I appreciate you highlighting that. It also came up. I was speaking at the Montgomery County Bar Association. I came up there as well. So
thank you.
People were paying attention, but we'll dig in. All right, next we'll go on to Gavin, there you are. Mr. Potashnik, you're up.
Thank you, Mr. Chairman. Mr. Vice Chair, members of the committee, Gavin Potashnik. I am the Deputy State's Attorney in Hartford County. I'm asking for an unfavorable report with respect to this bill. You know, it's really hard to follow Mr. Schellenberger's testimony there. He kind of stole my thunder with a lot of things that I wanted to say, but I do want to highlight a few things that I think the judiciary, cases on felony murder have limited the circumstances by which felony murder can be applied. I mean, there is the Campbell exclusions. There's also, the case involving Mumford. In both of these cases in tandem together, limit circumstances. It's no longer where someone's just standing there. You actually have to be participating in the felony. You have to show that the responsibility of one felon for the act of the other co-felon is limited to acts that naturally and necessarily flow from the common design. So in many instances, you would have a successful defense of felony murder if you're able to show that your actions didn't follow the common flow in design and in furtherance of. And I think there's a misunderstanding that if you're just standing there, you're guilty of felony murder, and that's just not accurate in today's prosecution. I would also note that there's some circumstances where felony murder is the right type of strategy for a prosecution. This is in instances where you have 2 people who enter a house to burglarize it, they kill someone and leave, and we don't know who pulled the trigger. And there's many instances where we have no idea who pulled the trigger. In both instances, these individuals point to each other and say, no, Bobby did it or Susie did it. It is better for the state then to go under a theory of felony murder because we know that both of them participated in this and there was a common flow in design that somebody pulled that trigger. Rather than if we eliminated felony murder in that circumstance, we wouldn't have to be able to charge first degree murder, even though there was at some point premeditation. I would also kind of reiterate Mr. Schellenberger had indicated about the retrial aspect of this. And I haven't seen the amendments on this, but the way the bill was presented online, the way that I read it, is that there's kind of mini trials that happen where a court would find that somebody fits the exception that is outlined in this bill, and then the state would have to drag out all the boxes from the basement and go over the testimony that was in the initial trial. We prosecute the trial that's in front of us, not the trial that we don't anticipate 20 years or 15 years or 10 years later. And I think it's unfair to ask for the state to be on the one who has the burden to prove that there was a first degree murder when that was not what was anticipated at the time of trial. So, I think there's some practical issues with this bill. I think that the issue of felony murder is a lot broader than some circumstances. And I would ask for the result. Thank you.
All right, thank you very much, Mr. Potashnik. Next, we'll have Mr. Riley.
Thank you, Chairman Smith, distinguished members of the Senate Judicial Proceedings Board. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chair for the Maryland States Attorneys Association. We seek an unfavorable report on Senate Bill 395. If this bill becomes law, the maximum the state could pursue in these sorts of cases will be a second-degree murder. To be clear, Maryland's law is not currently against Supreme Court precedent. That was stated during the proponent's testimony. That's their opinion. But currently, Maryland doesn't have to change its law based on what the Supreme Court has done. Maryland's law is perfectly constitutionally legal as it stands today. I'll tell you about a case in Caroline County. We proceeded on a felony first-degree murder theory in 2015 with the juvenile. Trayvon Farrow was killed by a single gunshot wound to the chest at the age of 23. In the house was his pregnant wife and 2 stepchildren. The defendant, William Willis, at the time of the murder was a juvenile. Willis was found guilty of first-degree murder, felony murder, after a not guilty agreed statement of facts was read into the record. These 4 written pages detailed how Willis obtained or found a 12-gauge shotgun, stole ammunition, sold the gun and ammunition to the eventual shooter of Mr. Farrow, planned the robbery of Mr. Farrow, whom he suspected of possessing marijuana, cash, and was unlikely to contact police if robbed, was one of the few individuals who had knowledge of Mr. Farrow's hidden console in his residence where he kept those items, provided the masks that were used during the robbery, participated in the robbery where Mr. Farrow was murdered, and later approached Mr. Farrow's widow on the street asking what occurred while knowing exactly what had occurred and who was responsible. He was found guilty and sentenced to life sentence, however, suspending 25 years active. You heard a lot of talk about life sentences. Life sentences can be suspended down to a term of years. If this bill becomes law, at the most Mr. Willis could be charged with is home invasion in that case. That would not be a just result. We're talking about accountability here to the surviving members of Mr. Farrow's family. We're not talking about, we're talking about a defendant to correctly capture the actions in the nexus of the crime that has been committed. This contains a look-back provision that would vacate the first-degree murder conviction and force the state to attempt to prove second-degree murder and limit the state to presenting a 4-page document that was read into the record. It's my belief as well that this bill would allow to prove second-degree murder by clear and convincing evidence, which may not be constitutional. If a crime as serious as homicide needs to be retried, it should not be handcuffed by the state to a case on the record. Thank you. Just one sentence. The family of Trayvon Farrow should not have to face the possibility that the conviction could be vacated and retried in such a haphazard manner. Thank you.
Thank you, Mr. Riley. And finally, we have Mr. Kroll. Steve, you're up.
Thank you, Mr. Chairman, members of the committee. Good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, the Executive Director of the Maryland States Attorneys Association. And we are asking for an unfavorable report as to Senate Bill 395. I want to echo and agree with Mr. Schellenberger, Mr. Riley, and talk a little bit about Mr. Potashnik's mere presence. In every felony murder case that I have seen, the judge gives an instruction that mere presence is not enough to find someone guilty. That is an instruction that's given in every case beyond a reasonable doubt. And that's, like I just mentioned, given all the time. And I just want to agree with, again, Mr. Schellenberger, Mr. Riley, Mr. Potashnik, just pointed out to the committee, and would ask for an unfavorable report as to Senate Bill 395. Thank you very much.
Thank you, Mr. Kroll. And with that, that'll conclude the testimony for Senate Bill 395. We'll now move on to the committee for questions. And I see that Senator West has his hand raised. So Senator West, you're up.
Thank you, Mr. Chair. I've got a couple of questions. Let me start, if I could, with Ms. Kamens. You stated that trying to convict a juvenile of felony murder is a violation of the 8th Amendment to the U.S. Constitution. Has that question ever been raised before a federal or state court, to your knowledge, and how's the court ruled?
Yes, Senator West. I believe that the source of that information is in the Supreme Court cases that have been referenced at this hearing. The Supreme Court has talked about that as a justification for taking away mandatory life sentences for life without parole sentences for juveniles, and talking about the excessive and disproportionate sentence imposed upon a juvenile who's, as a result of neurological shortfalls in their development.
Well, I'm correct, am I not? And the Supreme Court did not hold that to convict a juvenile of felony murder is unconstitutional under the 8th Amendment. What they held
correct.
was that the the penalty of life without parole, that would be a violation of the Eighth Amendment, correct?
That's correct. And I would point the senator to the cases that talk about the Eighth Amendment and what constitutes cruel and unusual punishment and what constitutes excessiveness and disproportionateness in sentencing juveniles as a result of the fact that, I mean, I'm extrapolating, obviously, for the purpose of felony murder, but felony murder carries a life sentence, a mandatory life sentence. So the court doesn't have discretion but to impose that sentence. And what the cases discuss is how that mandatory life sentence imposed upon people who don't have the ability to foresee the risks of their actions as a result of established neurological science is what is unconstitutional. So I think that the answer to your question does lie in those cases, albeit not specifically addressing the constitutionality of felony murder.
Thank you for your answer. Senator Carter, let's talk about Mr. Potashnik's case. The hypothetical, which I suspect in many cases is not so hypothetical, is that 3 youths go into a house to rob the house, and someone ends up getting killed in the house. The occupant of the house gets killed, and then the kids run out and they get apprehended by the cops, and no kid will acknowledge that he pulled the trigger. Without a felony murder statute, what is the prosecutor to do in terms of convicting the 3, each one of whom points the finger at somebody else? How can you get a conviction beyond a reasonable doubt under those circumstances?
Well, if there's evidence that the murder happened, then murder is still a possibility. We're simply saying that someone shouldn't be convicted of felony murder because of the fact that they participated or potentially participated in the underlying felony of the house burglary. But
only one person committed the murder.
no, we also have
Bill,
the scenario.
the other 2 aren't. I'm sorry.
The scenario that you raise happens all the time. In almost every case, you have multiple people that are participating in something, and there's a principal, and there's other people that are charged with conspiracy to do that same thing. I mean, it's a very common thing, and there's never a hesitation on the parts of state's attorneys to charge the people with conspiracy to commit the act, even if they can't prove that who committed the act specifically.
Well, wait a minute. I'm not a criminal lawyer, so maybe I'm speaking without knowledge. But if I were a prosecutor, I would think I would have to prove beyond a reasonable doubt that each of the defendants committed the crime for which they were indicted. So if you're going to indict a youth for having committed a murder, you'd have to prove beyond a reasonable doubt that that youth committed the murder, absent a felony murder statute, correct?
You have to, well, you could have the youth, that person could still be charged with conspiracy to commit the murder.
Suppose the person's defense was, I had no idea a murder was going to be committed. I was there to rob a house.
That's always the case. Most people that are present would claim that they had no idea that was going to happen.
But under the circumstances, unless you can prove that person pulled the trigger, how can a prosecutor possibly convict the person beyond a reasonable doubt?
Without getting too technical, there are ways to prove it. You have things such as fingerprints, gun residue, who was in possession of the gun. You have those kinds of pieces of evidence that could be used to try to determine which specific person was culpable or was the principal. That's done all the time as well. But
all right, let me turn to my third question then, and that is this question of the look back. So in your bill on page 3, it says the court shall hold a hearing limited to the record of trial, which the state must establish by clear and convincing evidence that the moving party could be found guilty. The standard is beyond a reasonable doubt, isn't it? It's not clear and convincing. How is it constitutional to convict someone based on clear and convincing evidence?
So assuming that we get rid of felony murder, which is not really that someone's been proven beyond a reasonable doubt to commit murder, we've convicted them ostensibly on the fact that they were involved in an underlying felony. I would argue that one, that's never been proven beyond a reasonable doubt anyway, that they committed the murder. I think that the bill simply gives an alternative way to sentence more fairly, still holding them accountable, but getting rid, finding a way to continue to sentence, but getting rid of the felony murder conviction.
Okay, well, let me get to Mr. Schellenberger and ask you if he could be unmuted, please. So 10 years ago, two youths went into a house, and the third served as the getaway driver outside. And they were all convicted of felony murder. When you convict someone of felony murder, do you try to establish at trial that the murder was deliberate, premeditated, and willful?
No, we don't, unless obviously we have overwhelming evidence of that. And your example is the perfect example. If you're not breaking into a house, then you don't need a getaway driver. And the place where you make the adjustment is not in the crime that's been committed, but in the sentence. That's where you can make the adjustment that Senator Carter is kind of looking for. And so a Caprio case is the perfect example. The driver who ran over Officer Caprio got life. The three who were participating in the burglary, the felonies that wouldn't need a getaway driver, but for breaking in, they each got life suspend all but 30 years. So they got convicted of felony murder, but got life suspend all but 30. So their culpability, while convicted of felony murder, the culpability was changed based upon the sentence that was given. And that's where they made the adjustment. And please remember, and I don't think we've mentioned this yet, felony murder is not just any felony. It's felonies that you all, the legislature, has determined should be able to be used for felony murder. And so it's usually, and it is, the worst ones. You just added carjacking a few years ago. There's burglary, which is always a dangerous thing when you go into a house. And then obviously rape and some of the other sexual assaults. So it's a very limited number.
Let me get to what I'm driving at. So
okay.
When you prosecuted the Caprio case, did you try to introduce evidence that the three culprits engaged in a deliberate, premeditated, and willful killing?
No, we didn't even attempt to do that because we had felony murder. And
okay.
as Mr.
So you did not.
Said,
so you did not. You just convicted them on felony murder, not on the usual first-degree murder grounds.
That's correct.
I'm looking at the statute that says second-degree murder is a murder that's not in the first degree, and there's nothing more to it. So here's what I'm getting at. Under this bill, under the look back, the state would vacate the conviction of felony murder and then resentence the moving party to enter a conviction of second-degree murder.
Right.
The standard for convicting someone of second-degree murder would involve proving that the person engaged in a deliberate, premeditated, and willful killing, would it not?
Well, yeah. I mean, second degree you can prove in a lot of different ways. There's also a theory under which you can prove second-degree felony murder with different felonies. But I mean, let's be honest. What we're doing here is we're giving a break to some people looking backwards because we're changing the law looking forward. And respectfully, can you imagine the outrage that would happen if we had to, if we were all starting all over again?
But my point is, if this bill is passed, a court is going to be directed to enter a conviction for second-degree murder.
Yes.
As I read it, I enter a conviction under section 2-204 of the subtitle, second-degree murder, when the elements of second-degree murder had never been proved 10 years ago.
Correct. Either in the trial or if a statement of fact was written.
Well, how can a court do that? Isn't that unconstitutional?
Well, I see all our professors shaking their head no, but I don't think they can do it. As Mr. Potashnik said, or Mr. Riley said, if you read a statement of facts and this statute says you're limited to what was presented in the first case and you didn't address any of those issues like the elements of second-degree murder, I don't know how you could enter the conviction.
Okay, I see. Looks like which of the professors were the? It looks like Ms. Kamens would like to address that. I'd like to get her answer to it.
Thank you, Senator West. I'm not a professor, but I am I am a criminal law practitioner and have been for a very long time. So thank you for giving me the opportunity to respond to that. I just want to dispel the misunderstanding that seems to be prevalent here, which is that the look back provision entails the judge to vacate the felony murder conviction and substitute it with a second degree murder conviction. And that is not the case. I hope we're looking at the same bill. What I could see perhaps some confusion, but what the bill does or purports to do is upon that proceeding that the defendant is entitled to, assuming he makes the prima facie showing and assuming it's been established that he has been convicted of felony murder, what the judge does is resentence. The conviction stays in place. So
wait a minute. I'm reading the bill on page 3. Maybe let's just go through the language.
Sure.
The court shall, 1, vacate the conviction under subsection B4, that's the felony murder conviction. 2, enter a conviction under section 2-204, which is the second degree murder conviction. And then 3, resentence the moving party, etc. So the court is going to enter a conviction of second degree murder. That's what the bill says, as I read.
Well, so perhaps, and my colleagues can chime in, perhaps you're looking at the pre-amended bill. The bill has been amended.
I don't have an amendment. I'm sorry.
Okay. So then let me just say this. Obviously, that is problematic, and that's where the confusion is coming in. But if I can just say that the bill as amended, and we've had a lot of difficulties with legislative services on getting this bill amended, and I really apologize that you don't have a copy of the amendment. So I can assure you, and I can assure Mr. Schellenberger and everybody else here, that the look back provision simply allows for the resentencing. The first degree conviction stays attached to that defendant for the rest of his life. All it does is allow for a resentencing to the maximum penalty for second degree murder that was in place at the time of the crime. So that could be 30 years or that could be 40 years.
Okay. That's helpful. Thank you.
Absolutely.
I don't have the amendment.
Okay.
I'm sorry. I don't have that amendment. And I'm not sure that those opposing the bill had it either. Mr. Schellenberger, you've now heard what the amendment purportedly says. Do you have a reaction to this based on the fact that there's an amendment which eliminates the vacating of the original conviction and the entering of a second conviction and merely says that there'll be a resentencing? He needs to be unmuted.
So you are correct. To my knowledge, none of us have seen the amended version because that is totally new to me. And I did have a huge problem with that. I really would like to see the actual language because that's one of my arguments. If you're going to vacate a sentence, how are you going to convict somebody of something that wasn't there? It was probably null pros or gotten rid of. The description that Ms. Kamens gave, it sounds like it could be done, but again, I'm now on policy and not the substantive law. I still have a problem with all this, and I think you're zeroing in on this concept of clear and convincing evidence and putting it in through all of this I mean, really what they should just do is write a bill that says, if you're convicted of felony murder, you get another resentencing, and oh, by the way, you're maxed out at 30 years. And I mean, that's what they're trying to do, but they're trying to do it in a clever way.
Thank you. Thank you, Mr. Chair, for the opportunity to ask multiple questions.
No, I appreciate it. Thank you, Senator West. And I guess I've got the answer to that. So Senator Carter, with your permission, will distribute the amendments to the rest of the committee. But obviously amendments are confidential until they're distributed. I wanted to give an option to Ms. Suter. I saw that you had your hand up twice, and Senator Carter, you do it, but I'll recognize Ms. Suter if you could provide just some additional background, because I know you wanted to chime in on the debate.
Right, Ms. Kamens actually covered it, I think. And so again, the mechanics of the hearing is simply to identify the category of folks who would be eligible for relief. And the reason why that's necessary is simply the fact that premeditated murder and felony murder are categorized as first-degree murder. And so it is just the process by which you're identifying who would be eligible for relief under the bill. It's not sort of the most straightforward process to identify them. But it's not on their guilt or innocence of first-degree murder or second-degree murder. It's simply identifying this category of folks who are eligible for relief.
Thank you, Ms. Suter. All right, now we'll move on to Senator Hedelman, and then we'll go to Senator Sidnor.
Thank you, Mr. Chairman. I have to tell you, as a non-practitioner, when I first learned about felony murder, I found it kind of mind-boggling that somebody could be sentenced to having been a murderer without actually participating in a murder. And so I guess I wonder if Ms. Suter or Ms. Meadows, Professor Meadows can comment on the Caprio case, since that is a case that keeps coming up. What would happen under this bill? I mean, no one is saying that people, as I understand it, so no one is saying that people who are participating in a crime should not be held accountable for their role in that particular crime. But when, sometimes if things go awry in the crime and an intentionality, I think is pretty important in assessing accountability. So I wonder if either one of you could talk about what would happen under this bill in that particular circumstance.
Thank you, Senator Hedelman. So in particular, in the facts of the Caprio case, it's important to remember, I think there was some confusion that somebody would only be able to, a prosecutor would only have the ability to go forward on second-degree murder, and that's not the case. All of the time in trials, you will hear that when talking about first-degree murder, a prosecutor will say it only takes seconds. All you have to do is stop and reflect on the action that you are about to take. And it literally is perhaps the seconds before a trigger is pulled. So it's not some sort of vast and complex scenario in order to prove premeditation, which is the necessary element to first-degree premeditated murder. So it's important to note that this doesn't take away the ability of the prosecution to prosecute people and punish people, juveniles in this case, for the crimes that they actually commit. So certainly in that scenario, the prosecution would be able to attempt to prove premeditated first-degree murder. And I can imagine other cases that I've reviewed in the course of my practice where a state could sort of establish sufficient evidence in that particular factual scenario to prove first-degree premeditated murder. So it's simply not the case that this is taking away any of the tools of the prosecution. So that's what I would say.
And I think the only thing that I would add to that is, we've talked about the Caprio case with respect to the 3 defendants who were not in the vehicle; they were still in the house, and so just to, Mr. Schellenberger has said those defendants received sentences of life suspendal, but 30 years. But I think that it's important to note that those were pleas. Those 3 defendants waived their right to a trial in exchange for that sentence, knowing that the threat of a life sentence was hanging over their head if they didn't enter that guilty plea, despite the fact that I think there's a very strong argument that none of the 3 could have foreseen that Mr. Harris would have done what he did. And so I just think that that's important to add to the conversation, that I think, charging first-degree felony murder is often used as a plea bargaining cudgel. And I'm not so sure that that's the business we should be in as a state when it comes to juveniles who are charged with serious crimes and when a life sentence is at stake.
Thank you, Mr. Chairman. And thank you.
All right, thanks. So, here to the gallery. So, do you want Senator Hedelman? I'm sorry. All right, I see Mr. Schellenberger. Equal time. I'll let you chime in here very quickly, and then
very quickly and very calmly. This bill, looking backward at the Caprio case, 3 defendants will come in and they will be found, their sentence will be, according to the original, vacated, but under whatever the amendment is, they will be convicted of second-degree murder and sentenced. That's what I've been told. That's what the bill says. If you all don't pass the amendment out, how can I talk about anything else if it's only the sponsors that get to look at it? But more importantly, going forward, if the Caprio case happened going forward and you took away felony murder, the felon who drove over the person could be convicted of premeditated or felony murder because they are the principal in the first degree, the actual killer. The three inside the house who were coordinating the burglaries would only be convicted of burglary. I don't want to hear about premeditation. They were not the principal in the first degree. They would only be convicted of burglary going forward if you pass this bill. Looking back, we'd have to change three of them. Going forward, they wouldn't even be convicted of murder.
Thank you very much. All right. We'll move on to Senator Sidnor, and we'll come, so go ahead, Senator Sidnor.
Thank you, Mr. Chair. And any of our state's attorneys, I welcome their response because I think the testimony has been the same about the whole second degree murder, and you can't, not first degree. So I'm trying to understand that. I'm assuming, are we looking at the language on page 3, lines 1 through 3? Is that what you all are using for the basis of this argument?
And just as a note, I just saw that the amendments were just emailed out to the entire committee. So if you check your floor laptops.
Okay, and I see Mr. Schellenberger is shaking yes. Now,
do you want him to respond, Senator?
No, he said yeah.
No, it didn't come to me yet.
No, you're shaking your head yes to that's the section that you all are referring to, correct? Now, I guess my read of it was that you can't be charged with felony murder based on the list of charges that were in line 7 through 26. But if I may, and this is for Mr. Schellenberger, and again, we've been talking about the Caprio case. So I'm curious if this tool called felony murder did not exist, would I be correct in assuming that the 3 young men that were in the apartment building likely would have been charged with burglary?
Yes.
Right.
In fact, they were charged with multiple burglaries because more than one house was broken into.
Okay. And the sentence for burglary is what?
20.
Up to 20 years. And the young man who killed Officer Caprio, he would have been charged with first degree murder, correct?
Correct.
Okay, and the sentence for that would have been?
Would have been life, either under a theory of first degree murder, which would still exist under the statute because he was a principal in the first degree, that is the person who did the killing, or potentially under a theory of intentional killing, which is classic first degree murder. So
Gotcha.
You are correct, but my point is, but for committing felonies in these houses, they wouldn't have needed a getaway driver, and therefore they wouldn't have been, Dante Harris wouldn't have run over Officer Amy Caprio. And that's why, as Mr. Potachnik said, we have to show action, a common flow and design amongst all the felons. And that's why you typically are able to convict a getaway driver.
So my question, and again, from I guess a public policy perspective, is why would justice not be served if there were no felony murder, charging the participants with the crimes that they actually committed rather than imputing a crime that one committed onto the others?
Because they are acting together in concert. And a lot of people wouldn't do these crimes by themselves. You know, Dante Harris wouldn't have been out in Perry Hall breaking into houses by himself. And that's why we have so many co-defendants nowadays. And unfortunately, particularly juveniles, is when they meet together, they feel emboldened to be able to do these kind of crimes together. And that's why they all should be held responsible for that which is a common flow and design out of committing a enumerated felony.
I guess, and I guess I'm in my thoughts probably more aligned with Senator Heddleman's in the fact that certainly people should be held accountable for the acts and crimes that they've committed, but one would think that in a country where we always say you need to be held responsible for what you do and you're your own person, that that in something as serious as this, that whole theory would kind of hold true, that you would be responsible for what actions you have committed.
But instead of talking about the Caprio case, look at my written testimony. Two people go in to do a robbery of a liquor store, A and B. You know, A does the shooting, but B, who is with them, says, shoot him, so he can't identify us. Are we all saying under Maryland law, the person who say shoot him should not be responsible for their murder when the other one pulls the trigger? Because that's the direction you're all going in. And,
well, that's a good. Actually, I was reading. I read that, and I was curious that, again, if felony murder did not exist, couldn't the person be held responsible for murder if they're saying shoot him?
Well, I think Professor Meadows brought up conspiracy, but remember, conspiracy, I have to show that there's an agreement. So that's a possibility, conspiracy to commit murder. But remember, you're now making felony murder. The only person responsible for the murder is the principal in the first degree, and that's the person who pulled the trigger. So while I might be able to convict the person who said shoot him, convict him of robbery, that's capped at 20 years. Maybe I can get conspiracy to commit murder, but then that gets complicated because I have to show there was an agreement. And, you know, so that's why felony murder exists. When you walk
I'm thinking even without felony murder, one would think if I'm encouraging you to kill somebody, even if I don't pull the trigger, that I will be held liable for that murder.
Well, certainly an accessory.
The others shaking their head that you could be.
And I'll say what Ms. Camus is going to say. The jury instruction for assault, aiding and abetting is aid and assist, instigate or encourage. So if I had those words, shoot him, I should be able to prove aider and abetter. But all I'm saying is no longer that I testify truthfully. No longer am I able to.
So nobody's getting off. I mean, you're gonna be held accountable for what you did. Is all I'm trying to get at.
In the robbery example I gave you, not in the example of the Caprio case.
Okay, thank you, Mr. Chair.
Thank you, Senator Sidnor. And so since her name was invoked, we're going to give Ms. Kamens a second to respond there, and then we're going to go to Senator Castley.
You know, it's hard to say it any better than Senator Sidnor said it, but since you've given me the opportunity, let me just emphasize that what is so preposterously unfair about convicting and sentencing people for the crimes that they committed? All that we're trying to do by this bill is not allow people to be convicted in sentences of crimes that they neither did nor reasonably could have foreseen that somebody else would do. And in this, and the other point, I guess, is that this bill only eliminates a small slice of crimes committed under certain circumstances. Obviously, and I think Mr. Schellenberger was reluctant to admit this, but finally did, you have accomplice liability all day, every day, if you can prove it. I mean, multiple people participating in some aspect of a crime, say the crime's first-degree premeditated murder. A whole big group of people can be convicted of first-degree premeditated murder if the state proves that they were all accessories under the law. You can also convict and sentence for conspiracy. Yes, you have to prove an agreement, but that's an element of the crime. And that carries a life sentence, for heaven's sake. Nobody's getting off. You can be convicted of the felony under this bill as well. If there's a handgun involved, you can get a 20-year consecutive sentence for that. This is hardly a big ask. And that's the only point I'll make.
All right, thanks, Senator Castle. You're up.
Thank you, Mr. Chairman. I go with Mr. Riley, State's Attorney down there. If I could, I'll give Mr. Schellenberger a break for a while. Mr. Riley, it's been my understanding that the reason that we punish the felony murder rule is because that you are acting basically in a conspiracy, and that those are so particularly dangerous and so powerful in what they can do. Mr. Schellenberger referred to, we embolden people. Having served in various special operations forces, and how effective you can be when you have a few other people assisting you, it does embolden people. It does make them incredibly effective to have a few more people, and somebody gets put in the position of being in the position that's more likely to result in harm. But why should the people in the conspiracy who are not closest to the tip of the spear, why should they be treated more favorably than the person who by chance was at the tip of the spear? Is that comport with your understanding, Mr. Riley? He's still muted. If you could unmute him. But just where we're going with this, and we keep saying, why shouldn't we just treat all these people as just a group of people who happen to show up on the same date, the same time temporarily, and they just happen to be fitting multiple robberies and carrying weapons and doing lookouts and getaway cars at the same time, and just treat them in that fashion? Can you just comment on that?
Yes, Senator. When you hear the proponents talk about brain development and those sorts of things, they talk about susceptibility to peer pressure and things like that. And that's probably appropriate when we're talking about a 14-year-old smoking marijuana, or a 17-year-old going over the speed limit because somebody's in the car going, go faster, go faster, go faster. But I don't know about you, Senator, but I can't tell you what age I learned to not pick up a gun and go participate in a carjacking, or go set a house on fire with people inside of it, or participate in a burglary of someone's residence with my friend out in the car with the motor running so I can get away. I don't remember the exact day, but probably a little bit younger than 25, which is what the proponents would have you believe, that only until I reach age 25 should I possibly be held to somewhat an account for those sorts of acts.
Yeah, and that troubles me, because I've been involved in cases where soldiers as 18 and 19 and 20 were trying to, under great pressure, were trying to raise various defenses, and certainly policemen are 18, 19, 20, 1, 2, 3, 4, 5. And I suppose we'll want to have a different standard for policemen below the age of 25 when they're involved in excessive use of force complaints, because who could possibly, 25-year-old cop who, once he's spat in the face from beating the crap out of somebody, hey, it's just his adrenaline, his brain's not fully formed. So I guess that's where we're going. But thank you very much, Mr. Riley.
Thank you.
All right, thank you, Senator Castle. All right, looking around the room for additional questions. Seeing none, that will conclude the hearing for Senate Bill 395. Thank you, Senator Carter, and thank you to the panelists. And that will also conclude our hearings for the day. We have a vote list, so let's do this. Let's take Let's come down at 4:30 to vote. 4:30. All right, I'll see you all later.